Thank you to all the thank yous, and it's been a wonderful evening already, hasn't it? And all that everyone here. I'd like to just make a couple comments to introduce Jenny. We first met at the Business Alliance for Local Food and Economies Conference a few years ago, and I learned very rapidly after hearing you speak that you're one of the more informed and intelligent and marvelous attorneys that have been in the areas of capital and securities and raising money and all of that, and you make it really understandable. And I really appreciated it then, and I'm really glad that you're here to bring it to our community and to the web and to the broader world of the internet. So why don't you just take it away and tell a little bit more about yourself and what your passions are, and how to do your presentation. And then the way that you like to do these events, if there's something that we're talking about that you would like clarification on that you didn't understand, then ask that. If you have a question that you would like additive information, hold that until we have a Q&A. Okay? But it's an open conversation, and if she says or I say something that you just didn't get, then we trust that maybe the opportunity didn't get it either, so speak up for clarification. And questions are questions, comments are comments, so let's make sure to remember that as well, because we want questions, and then when we have time for further comments, we want to have that conversation as well. Great.
Great, thank you. Thank you. So yeah, I'm told this is, I can barely see you all, but I'm told this is to be pretty informal, and so I'm happy to pause and answer questions if anything doesn't make sense. So yeah, I am an attorney. I went to law school. I graduated from law school in 1995, so I've been out of law school for a while. But after law school, I actually went to work at a nonprofit, and I was kind of the in-house counsel at the nonprofit, but mostly I was really doing program management. But I became really interested in small businesses. I was working in a low-income community in Oakland, and I saw how the small businesses were really struggling, and they were a really important part of the community, and their lives were incredibly challenging. So I just became really interested in helping small businesses. And then after 11 years at the nonprofit, I joined this other attorney named John Katovich at his small law firm. And that was the first time I ever heard of this thing called securities law. I had gone to law school, I had passed the bar, and I had never heard of securities law. Maybe there was a class at my law school, but I don't remember. And when I found out about it, I was really surprised. So one of my missions in life now is to spread the word about what I learned. Pretty recently, really about 7 years ago, is when I started learning about the law governing raising capital. And I like to make sure that as many people as possible know about it, because if I went to law school and passed the bar and didn't know about it, obviously there's lots of people out there that don't know anything about it. So I want people to be armed with the information and also know what their options are when they're trying to raise capital, whether it's for a business, some kind of venture you're trying to do, a nonprofit, whatever you're trying to raise money for, securities law can come into play. So I kind of gave away the answer to this question already. But does anyone want to shout out a couple of reasons? These chairs really do by themselves, like moving around the floor. But anyway, does anyone want to shout out a couple of reasons why they think it's so hard for small businesses to raise capital?
Securities law creates barriers to access.
I'll repeat them for the securities law creates barriers to access.
He's not a plant. That's exactly what I think. I feel like that is one of the main reasons why. There really is no lack of capital out there. It's just there's a lot of legal barriers that prevent that capital from going to small independent businesses. So I'm going to talk about securities. So these cartoons were drawn by Janelle Orsi, who's another lawyer who's totally committed to being a lawyer for the new economy. And so, she's a good cartoonist. She lets me use her cartoon. So a lot of people don't even really know exactly what is a security. So it's basically any time you try to bring investment into anything you're trying to do, whether it's a business, a venture, a nonprofit, etc., that could potentially be a security. And these things happen all the time. I mean, how many times have you gotten an email saying, oh, I'm looking for an investment in my business, or, talk to someone who said, oh, I'm looking for an investment. That is the offering of a security. And the problem is a lot of people don't realize that sometimes when you are offering a security, you might be doing it in a way that's illegal. There are laws that were set up at the early part of the 1900s to protect investors from securities offerings that they might lose money in. And the Securities and Exchange Commission is the federal regulator of that, and then there are also state-level regulators. So you need to know a bit about securities law before you try to raise money for anything. So the first securities laws were actually adopted by the states. A lot of people might have heard of the 1933 Securities Act, which is kind of the famous federal law that was passed after the crash of 1929, where there was a real strong feeling of we need to protect investors. But it was actually the states that started passing these laws long before that the Congress did, the federal Congress. And interestingly, the first one was adopted by Kansas, and the reason they adopted it was to keep Kansas money in Kansas and help local farmers and small businesses rather than enriching New York Stock Exchange speculators and gamblers. And that's a quote from 1911 when they adopted the first securities law in this country. So I just find that really interesting that the purpose of the original securities laws was to keep money local, in local communities, in local businesses. And as we know, that the securities laws actually now have a very different effect. So this is the effect of our current securities laws. The total U.S. economy is pretty much, by certain measures, is half small business and half large business. So in terms of numbers of employees and in terms of production, it's pretty much half giant multinational publicly traded companies and half small independent businesses. But yet, if you think about it, normal, everyday people who might have some money to invest, whether through their retirement accounts or through like a little extra money they may have on the side to invest in a mutual fund, almost all of that money is invested in only one half of the economy, and that's the giant multinational corporations. And the reason for that is the securities laws make it pretty much illegal, with some exceptions that I'll talk about, for small businesses to solicit investors, to solicit the public. Whereas big giant multinational corporations have the money to do IPOs, which is a registration process that they do with the SEC that actually makes it legal for them to solicit the public and to be traded on the stock exchange. So just to get into a little more detail on what is a security, a lot of people don't realize how broad the definition is. So under federal law, it's any contract or scheme or transaction where someone puts their money into something and they're led to expect profits through the efforts of a third party. So if I'm investing in my own business, that potentially wouldn't fall under securities law. But if I'm investing in someone else's venture and I'm just sitting back and waiting to get some return on my investment, that's a security. So it could be a loan, it could be stock, it could be just about anything where the investor is expecting to get some kind of a return from the efforts of someone else. And interestingly, and a lot of people don't know this, but under state law, in 15 or so states, including California, the definition is even broader than that. And that's because California was the one that first created this test called the risk capital test. And it was adopted by the California Supreme Court in a case called Silver Hills Country Club versus Sobieski. And what happened in that case was the people were developing a country club, and they decided to pre-sell memberships in the country club as a way to raise money to actually build the country club. Now, under the federal definition, that doesn't sound like a security because there was no promise of any profit from that investment. All it was a pre-sale of a membership. But the California Supreme Court said, no, you know what, we think that is a security. And we're going to go ahead and say, even though under federal law that wouldn't be considered a security, in California, we want to protect Californians from those kinds of offerings. And we think that people need to be protected even if there is no promise of a profit. So the risk capital test is these 4 points. Are the funds being raised for a business venture? Is the offering being made to the public? Are the investors powerless to affect the success of the thing they're putting money to? And is the money at risk? So the way I like to explain, that's the big important question, is if you buy a gift card at Starbucks, it's probably not going to be considered a security because it's not a very risky investment. You know, chances are you'll find a Starbucks to buy coffee at, but if you buy a pre-sold gift card in a business that doesn't even exist yet, chances are that will be considered a security under California law and also the law of about 14 other states. So I like to point out that many of the things that are happening right now on some crowdfunding websites like Indiegogo, Kickstarter, Rocket Hub, there's a lot of pre-sales going on of things that don't exist yet, and I really think that that's very risky. I tell all my clients, don't do that, you know, because I think there is a very good chance that the state of California or some other state securities regulator is going to start to crack down on that. So what if something is a security? Well, all of a sudden you're covered by this securities law regime, which is both federal and also every state where you're offering the security. So if you're doing a Kickstarter campaign, theoretically you're going to be subject to more than 51 different jurisdictions. It's also it's U.S. Virgin Islands, it's Puerto Rico, it's Guam, a few other places. So you actually have to comply with the laws of all those different jurisdictions. So the default rule is that if you're selling securities, you have to do a federal registration. And basically a federal registration is the same thing that people do when they do an IPO. It's a big filing that you do with the federal government where you go back and forth with them and you have to do a very complicated set of documents and they ask a lot of questions and it can take 6 months to a year. So that's the default rule. Plus you also have to register in every state where you're offering securities. If you do a federal registration, the state level requirements are a little bit less, but still you do have to do a filing in every state. So it's quite expensive, obviously, to do that. Doing an IPO can be very, very expensive. So there are some exemptions to that requirement. Obviously, you know, people sell securities all the time without doing the full federal registration, without doing an IPO, but most of the exemptions involve selling only to accredited investors. And an accredited investor is defined under federal law, and it's someone who has at least $1 million in assets or $200,000 in annual income, or if it's a business, at least $5 million in assets. So, and if it's an individual, the $1 million in net worth just cannot include their home. So for individuals, it's probably about 3% of the population. So it's a very, very tiny percentage of the population where the securities laws assume that these people, these very wealthy people and wealthy organizations don't need as much protection, and therefore it's easier to offer securities to these people. So a lot of times, that's why when people are trying to raise money for a business, a lot of times they'll go after a VC or an angel or both, because those are accredited investors. So it's much easier from a securities compliance perspective to go after those kinds of investors. But as you can see from the slide, it's a tiny percentage of businesses that actually get that funding. So if you're going to go after those investors, chances are you're going to be wasting a lot of time. So there actually are legal ways to raise money from the public, from the crowd, that don't violate securities law, and I'm going to talk about those. One is, of course, as I said, an IPO, and of course, you know, that's very expensive, so I'm not going to talk more about that. Then there's a new law that was passed last April called the Crowdfund Act. It hasn't gone into effect yet. It's part of the Jobs Act. You might have heard about that. So I'm going to talk about that, and then I'm going to talk about a couple of other tools, especially a tool that we call the direct public offering, which is a tool that actually allows you to offer an investment opportunity to the public and not have to worry about whether they're accredited or not. questions so far? Okay. So I'm just going to tell the story of the Crowdfund Act, which was part of the Jobs Act that was passed back in April 2012. I like to tell how it all came about because I was actually involved in this thing actually happening. So back in 2009, my friend Michael Schumann, does anyone know who Michael Schumann is? Have you heard of him? He's a really great author and speaker on the issue of small independent businesses and how important it is for them to be supported. And so he, had given some thought to the issue of securities law and how hard it is for small businesses to raise capital. And he wrote this article in this publication put out by the San Francisco Federal Reserve, where he made a little proposal. He said, and he almost said it kind of like as a joke. He said, why don't we allow businesses to raise up to $100 per person and not make them go through this huge hassle if they're only raising $100 per person? And maybe we'll cap the total at, I think he said, $250,000. So he almost was just saying it to make a point, like, do we really need to protect people if all they're investing is $100? Because under current law, even if you're only investing $1, theoretically, the company would have to go through this whole process to be able to offer securities to the public. So he wrote that article, and we kind of just laughed about it, and we wondered, I wonder if anyone will ever think through that idea as a possibility. So then, a little bit later, this guy named Paul Spinrad, who works at Make Magazine, had been really interested in a similar issue because he works with makers who often need to raise money for their projects, and he knew about securities law and was really frustrated by it. And he saw an article that I had written about the topic, and he contacted me and he said, why don't we, and we talked about Michael's proposal, and he said, let's write a letter to the SEC and propose that. Let's propose what Michael said. There's actually a process where you can write a letter to the SEC. It's like a formal proposal that you can make to the SEC. So we needed a little money to cover our costs to do that. My nonprofit, a nonprofit that I co-founded called Sustainable Economies Law Center was heading up that effort. So we raised some money to cover our costs, and we had some summer law student interns, and we wrote the letter, and I actually signed it, but the law student interns really wrote it. And so this is the letter. This is the SEC website, and it shows our petition on there. It says, request for rulemaking to exempt securities offerings up to $100 for registration under Section 5 of the Securities Act of 1933. So it was almost like, come on, SEC, we really want to challenge you here to make a tiny little exception that would help a lot of people. It's not a lot of money, but it's the first step. So this was the letter. We got a lot of letters of support. Paul Spinrad did a really good job of getting the word out about it, getting people to support it. And the letters of support were up on the SEC website. Okay, I just went too fast. So we submit this thing to the SEC, and we think, oh my God, nothing's going to happen, But amazingly enough, word started to get out about this. And a guy named Woody Neese from Florida, has anyone heard of Woody Neese, Sherwood Neese? He's now kind of known as a major player in the crowdfunding arena, but at the time, he was just a guy, like an entrepreneur in Florida. He loved the idea, and he started pushing the word out there about it, and he had a lot of really good connections, and he was really good at kind of publicizing it. He got Whoopi Goldberg to sign on saying she supported the idea. So all of a sudden, it really started to spread. Some of us went to an annual conference that the SEC holds for small businesses to talk about the problems that they're having. And at that conference, they met, some of my colleagues met someone from the White House who was really interested in the topic. So anyway, by some miracle, it ended up going to Congress and the President. There were people in Congress and the President that supported the general idea of creating an exception to the general rule that you have to register a securities offering for very small investments, where each investor is only putting in a small amount. So this is from the White House website showing that the president is like proposing this idea. So that was really cool. And then, not to be outdone, some right-wing Republicans in Congress started to support the idea too. And, so they could show up President Obama, I guess. And so then they started holding hearings on the topic, and then they actually passed a law. The House did, 345 to 10, it passed the House, and it was an exemption that it was a very short law. It was like very clear and simple, and it basically said for small investments up to, I think it was up to $10,000. So they kind of went up from the 100 that we had originally proposed. But they actually adopted this in the House. So that was really amazing. Then what happened next is that some Democrats in the Senate got a little worried that the law was too not protective enough of investors. It was a very short law. It basically said as long as you're raising less than $10,000 per person and no more than, I forget what the cap was, maybe $1 million, and you do a couple little other things, you're fine, you don't have to worry about anything. And so the Senate got their hands on it, and unfortunately they added a whole bunch of stuff that kind of wasn't great. And they did it in just a couple days, so there wasn't much time to really respond to it or say much about it. But the law did pass with those changes, and it was signed on April 5th, 2012. I actually went to the White House for the signing, and what it does is it allows people to raise up to $1 million, where each investor can invest no more than 5% of his or her annual income or net worth. The offerings have to be conducted through an intermediary. So in the original law, this was not the case. You could have gone out yourself and done the offering on your own, but because these Senate Democrats were nervous about how this would be regulated, would this lead to all kinds of problems, they said you can only do it through a registered intermediary. And this intermediary would have to get kind of a license from the SEC and would also have to be a member of FINRA, which is the private financial regulatory organization that regulates brokers. So you will have to go through a registered intermediary. Another thing they put in there is that if you're raising more than $100,000, you'll have to have reviewed financials, and it's very expensive to get. You have to hire a specialized CPA to prepare review financials, and it can be several $1,000s. And if you're doing over $500,000, you may also have to have audited financials. The great thing about it, though, is you will be exempt from state-level registration for the most part. So you could do your offering potentially in all 50 states, where, as under current law, you have to comply with every single state law. So the way the law was written, it left a lot of openings it kind of left a lot of things vague. And it said, and then it would just say, as the SEC shall decide, shall make rules about, And so basically, this law cannot go into effect until the SEC makes some very detailed rules about how it's actually going to work. And the rules will have to apply both to these intermediaries and to the people who are making the offerings, called issuers. And not only that, FINRA is going to also have to make rules for the intermediaries. So the Congress set a deadline for the SEC to finish their rulemaking process, and that deadline has passed. And as far as we know, we're not super close to this going into effect. So a lot of people ask me, what do you think it's going to be like? What's it going to mean? And I always say, I have no idea, because until we see the rules, or at least a first draft of the rules, we have no idea what it's going to look like, because the legislation left so many things open. So if you see an advertisement for a $1,000 conference in Las Vegas to tell you everything you know about the new crowdfunding law, save your money, because nobody knows yet. So one thing I don't like about it is the fact that you have to have this intermediary. I'm a big fan of people being able to go out and raise money for their own companies and not having to be quiet about it. The law actually says the issuer that's raising the money will not be allowed to talk about their offering at all, and all they can do is refer people to the website of the intermediary.
And just question, the intermediary is a registered broker-dealer?
Good question. So does the intermediary have to be a licensed broker-dealer? And the answer is no. That was a very interesting part of the law, because up until that law was passed, it was definitely the case that if you're going to be a platform where you're selling securities, you would have to be a licensed broker-dealer. But this law actually created an exception to that rule that said you could be one of these portals or intermediaries that sells securities under this new crowdfunding exemption without a broker-dealer license. But you're somewhat limited in what you can and can't do if you're one of the ones that doesn't have a broker-dealer license. And a lot of people are predicting that most of them, if not all, will probably end up having a broker-dealer license, because unless you do, it's going to be really hard to operate a good portal. But theoretically, you don't have to be a licensed broker-dealer to operate a portal. So I've stayed involved to some extent as the rulemaking process goes forward. I'm working with American Sustainable Business Council on some advocacy to try to make sure that this law will work for small businesses. So what we've talked to them about is creating a two-tier approach to the regulation, that there might be like a lower tier for smaller offerings, but we'll see what happens. And as I said, it's completely unpredictable what's going to happen, and we have no idea. But if you want to learn more, there is some stuff on the SEC website about this under the Jobs Act. The Jobs Act actually had a bunch of different sections in it. The Crowdfund Act is just one part of it. The Jobs Act overall did some other interesting things for securities law, but I won't go into that now. So I'm going to mention a couple of 4 strategies before I talk about the DPO that are some other creative ways to raise money. I think they're somewhat limited, but I like to mention them. I like to say we know of about 5 different categories of ways to raise money. So DPO is the 5th one that I like to talk a lot about, but I'll mention the other 4 because they can work for some people. So one is just trying to fall outside of the definition of a security altogether. And as we talked about, that's very difficult because the definition is so broad. But if you're, let's say you're an existing business. I was just on a webinar today with this company called Credibles. And what they do is they do pre-sales of gift cards for food businesses like restaurants, farms that sell eggs, things like that. And their position is, and I think it's a pretty valid position, is that because they will only work with businesses that already exist and are already in business, doing that probably does not fall under the securities laws because the risk is pretty low. So you could do something like that. We have some other clients that did pre-sales, like Awaken Cafe in Oakland is another one that did pre-sales to expand their business. There's also, obviously crowdfunding campaigns that are completely donation-based, maybe with a small perk, I think are safe. Zero interest loans, I think there's some debate as to whether that would be considered a security. Kiva does zero interest loans and takes the position that those are not a security, although I think that's a little bit risky because you are putting your money at risk. If you're actively involved in the business, it's not a security because, as we recall, the definition is when you put your money into something that you have no control over. Another one is public-private partnerships, and that's probably not the best name for it. It's what I really mean by that is when you there are businesses out there that are doing things that help nonprofits to achieve their goals, and then there's also businesses that are actually part of a nonprofit or a subsidiary of a nonprofit. So there are some situations there where you may be eligible for a grant. So one example I like to give is, which one is it? Mandela Foods Co-op, which is in Oakland. And they are a business, they're a worker-owned co-op, but they have a very close relationship with a nonprofit, and the nonprofit's purpose is to create job opportunities and job training and asset building in a low-income neighborhood in Oakland. And because the co-op helps them fulfill their mission, they're actually able to give some of the grant money to the co-op to fund various parts just something to think about if your business has some relationship with a nonprofit or maybe with a local government who might be able to take advantage of grant money. Co-ops are a separate category only because there are many states where there are securities law exemptions for co-ops. And even at the federal level, there's an exemption from the registration requirements for farmers, certain types of farmer co-ops. So one example is Organic Valley is really lucky because they qualify for the federal exemption for farmer co-ops, so they don't have to go through the whole federal registration. And under that federal exemption, they also have exemptions at the state level. So that's a great thing to be if you can qualify as a farmer co-op. But also, for example, in California, there's an exemption for co-ops in California as long as each person isn't putting in more than $300. So you could do a public offering of securities in California if you're a co-op as long as each person isn't putting in more than $300. And then of course there's private offerings, which is kind of the most common way that people raise money. It's like when you go to an angel or a VC, that's basically a private offering. But some of our clients have gotten creative in how they do those and maybe push the envelope a little bit on a private offering. So one example is Gather Restaurant, who is actually, they were not our client at the time they did this, so I'm not sure I would have endorsed everything they did, but they did a private offering to open their restaurant of securities, and they ended up with 60 investors, including, under California law, you're actually able to have up to 35 unaccredited investors as long as you have a substantial pre-existing relationship with them. So you can kind of stretch private offerings to include a broader base. But the thing about private offerings is you cannot advertise to the public. You can't put it up on your website, you can't put it in your social media, you can't hold a press conference. You have to do it all through the channels of people that you already know or through brokers who can connect you with accredited investment. So now I'll talk about my favorite one, direct public offering. So what exactly is a direct public offering? So this is, to me, like the most similar to what this new crowdfunding law will allow once it goes into effect, because it actually allows you to raise money from the public. You can do public advertising. You don't have to worry about whether your investors are accredited or unaccredited. And in some ways, it's better than what the new law would allow because there isn't a cap of $1 million. You don't necessarily have to have reviewed or audited financials. You don't have to cap what each investor puts in. So basically, a direct public offering, there are many different legal pathways to do a direct public offering, but generally speaking, it's when you offer securities to the public, and you can offer any kind of security you want. It could be stock, it could be notes, it could be a convertible note, it could be a revenue sharing agreement. And you can advertise it, and you don't have to worry about whether you don't have to ask all your investors to sign something saying, yes, I'm a millionaire, you know. So, and generally there's no underwriter involved. You're selling directly to your potential investor. So how is it legal? So generally what we do is we find an appropriate federal exemption from the registration requirements. And this is just a list of some of those. There's an exemption for nonprofits. So if you want to raise money as a nonprofit, nonprofits can go out and do securities offerings. So for example, if obviously you might apply for a lot of grants and stuff like that and donations, but you could also go out and raise money for people as in the form of loans. That would be considered a securities offering, but it would be federally exempt because there is a nonprofit exemption. But you still have to do a state level registration. So in California, for example, a nonprofit can do a public offering, but it has to do a state level registration. So for our clients, we help them register at the state level and we help them find an appropriate federal exemption. So these are some examples of direct public offerings, recent and past. I'll talk about a few examples. So this is one of our clients, Farm Fresh to You, which is also known as Capay. They are a pretty large business that does delivery of produce all over, organic produce all over the state of California. And they decided they wanted to let their customers invest in their business. So they created something called the Green Loan Program, which which offers a loan instrument to their customers, or really anyone who wants to invest as long as they're a California resident. And the interest is paid back in credits towards the product. This is another client of ours that's based in Massachusetts. Theirs was just recently approved. They're actually a worker co-op, and they wanted to bring in outside investors without voting rights, because in a co-op it's really important that only the workers have voting rights, but they're raising money from in the form of preferred stock from outside investors, and they're offering it in Massachusetts and Vermont, so we had to get it approved in both Massachusetts and Vermont, which wasn't that difficult because Vermont was quite friendly and they just sort of went along with whatever Massachusetts said, so that was nice. This is one in Washington State that's raised almost $600,000, and their minimum investment is only $100, and they're selling common stock. This is like a retail store, and when we worked with them, they were a total startup. They hadn't even opened their doors yet. Now they're actually open for business. This is one in Oakland, People's Community Market. They're trying to open a really nice market in a low-income area of Oakland. And they're also a total startup, but they've already raised, I think they've already raised about $300,000. They need to raise a minimum of $500,000 to be able to open. So they have a few more months to do that. So if you're interested, check it out. And then we ourselves, Cutting Edge Capital, we're doing one too. So it's totally legal for me to say, if you want to invest in my company, talk to me afterward. You have a year when you register these kinds of offerings. You have a year to raise money. So ours is open until the end of June. We've already raised about $120,000. And what we're offering is a revenue sharing agreement. We decided we didn't want to sell equity or debt. So what we're doing is we're giving our investors a percentage of our revenues every year for the next 5 years. So there's lots of advantages to direct public offerings. Of course, you have a much broader pool. If you're only going after accredited investors, it's a tiny percentage of the population, whereas if you're going after everyone, because with a direct public offering, you can still go after accredited investors, absolutely, but you can also go after everyone else. You can keep control of your company, you can do public advertising, you decide what you want to sell, so there's no negotiation. You decide, I want to sell preferred stock, or I want to sell a revenue share, and you set the terms of the deal. And all of our clients have done some very creative things. The issue of exit is big. When you're offering an investment, you have to think about, how are my investors going to get out? Or if I don't think about that, then what they're probably going to do is start pressuring me to sell the company. So for example, People's Community Market sold preferred stock with a 3% annual dividend, or is selling preferred stock with a 3% annual dividend, and their investors have the right to buy back, the company has the right to buy back the stock, let me put it this way, the investors have the right to sell their stock back to the company after 7 years for the price they paid. So we're really hoping that the dam breaks one of these days, hopefully not too long from now, and people will start investing more of their money in these kinds of investments instead of the stock market. As I mentioned before, right now almost all of our money is invested in the stock market. It would be nice if at least a tiny percentage would start to migrate over to these kinds of businesses. And little by little, we think the dam could break and we can start to see some major money rushing into our local economies. So I think that's it.